Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 147. Three cases, of course. The first case builds on our recent run of cases dealing with privacy issues in the Employment Tribunal. And I'd also like to say thank you to Claire Darwin, who got in touch after the last episode when we looked at this issue and forwarded on a reference to a relevant case which also looked at something similar. I'll come back to that. Actually, whilst we're on the subject of people getting in touch, thank you also to the listener who got in touch and said that she enjoyed the podcast episode, but whilst listening to the NDA podcast, she was very worried about she was going to catch a cold just from listening to me. So my apologies if I sounded very coldy indeed. Second case, well, it's an injunction which protects against the disclosure of information by an ex-employee. So there's another freedom of expression link in that case. And the third, well, it's a slightly odd case because I was absolutely convinced this point had been decided years ago, but apparently not. One of the joys about doing the podcast is that I'm learning too. Please don't forget, of course, podcast is available via iTunes, the Mayor Brown website, YouTube, the Twitter feed, Nicholas Robertson at Nicholas ROBER11, and we post out the links to the cases on that Twitter feed, of course. I ought to mention as well, while we're on the subject, we've got an employment blog that's up and running. And if you go onto the Mayor Brown website and look at the employment law blog, it aims to post out on a regular basis on employment and pensions matters. So hopefully that'll also be a useful source of information for people. So, on to the case. Okay, A and the Secretary of State for Justice. And this is an EAT decision dealing with privacy issues. Let's start with the facts as applicable before the EAT. Claimant was a probation officer who worked for and was then dismissed by the Probation Trust. During an early part of her employment, the claimant had a short relationship with someone who'd been a resident at the place where the claimant worked, and this in turn led to a child being born. Now, the man the claimant had the relationship with is given the letter J in the judgment, so that's how I'm going to refer to him. The relationship between the claimant and J breaks down, as I say. J then files a complaint against the claimant, saying that she had abused her position in the course of her relationship with him. The claimant gives a very different version of events. She says there were elements of abuse within the relationship against her by J. And to add to what is obviously a very troubled tale, her child, who is identified by the letter L in the judgment, that's what I'll do too, is apparently autistic and suffers with anxiety. Claimant was dismissed following the complaints levelled by J against the claimant, and she then brought unfair dismissal proceedings, and those too were decided against the claimant. However, the claimant, whilst the tribunal proceedings were on their way through towards a final hearing, applied for and persuaded an employment judge to make an anonymisation order under Rule 51 of the Employment Tribunal regulations. The judge, conducting the final hearing, altered this and instead made a restricted reporting order. The appeal to the EAT was brought by the claimant, saying that she still wanted an anonymisation order to be made, and the judge had erred in discharging this order and instead making the restricted reporting order. Rule 50 of the Employment Tribunal Regulations 2013 allows the tribunal at any stage of the proceedings, either on its own initiative or after an application to make an order, to prevent or restrict the public disclosure of any aspect of the proceedings. It can do so if it considers it is necessary in the interest of justice or to protect the convention rights identified of any person. The tribunal is instructed under Rule 50 (2) to give, quote, full weight to the principle of open justice, unquote, and also to the convention right on freedom of expression. Obviously, the main difference between an anonymisation order under Rule 50 and a restricted reporting order is that the restricted reporting order falls away when a final decision is reached in the tribunal proceedings. When considering Rule 50, the EAT said the tribunal should approach this in two stages. First, they had to consider the basis on which an order could be made under Regulation 50. In other words, was it in the interests of justice or was it to protect the convention rights of an individual? Then, secondly, those rights had to be weighed against the principle of open justice and the right to freedom of expression. The EAT pointed out that the ability to make an anonymisation order under Rule 50 to protect convention rights was not limited to the convention rights of the parties in the litigation. It was to protect the convention rights of any person. As I'll explain, that point becomes very important. The judge at the stage of the Employment Tribunal hearing, when discharging the anonymisation order and substituting the restricted reporting order, said that he was not convinced that the claimant's objective of preventing her child from reading about her father was sufficiently strong to justify the anonymisation order being made. Her father was not a party to proceedings, the judge said, nor was he a witness. On that basis, the Employment Tribunal judge did not accept that the case involved a significant discussion about the child's father, such as to justify the anonymisation order. The EAT disagreed with the tribunal judge's approach. The Employment Tribunal judge had, in the view of the EAT, not considered properly the child, L's, convention rights. The tribunal had an obligation to consider and respect those. L had a right to a family life and the right to a private family life. Given that L is autistic and apparently suffers from anxiety, the EAT said the need for respect of her right to a family life, quote, may be all the more pressing, unquote. In the family court, and I should add in passing that there was some suggestion that proceedings were going on in the family court too, if I read the judgment right on that point, the court pointed out that L's identity would have been protected throughout the proceedings. On that basis, the judge said that she thought, at the EAT level, she thought a similar level of protection should be given to L in the circumstances of an employment dispute between mother and employer, where the circumstances in which L was conceived and the nature of the relationship between her parents was likely to be discussed. So this is a matter where even the claimant herself had somewhat struggled to articulate this aspect of her case, but the EAT took the view that open justice and the right to freedom of expression did not outweigh the child's right to a private family life. There's no public interest in her being identified. The claimant had asserted that the claimant herself had an unusual surname. This doesn't seem to be challenged. So there were grounds for believing that if the parties were named, this in turn would lead to identification of the daughter. And the court said, although the public might have an interest in reading about an alleged abuse of power by the claimant who was a probation officer, those issues could still be properly ventilated and read about whilst protecting L's interests by an anonymisation order. Clearly the facts in this case make for sad reading. However, I do think it's a useful case to have in mind. If you look at it just purely as a lawyer, this clearly turned on the convention rights of an individual who was not a party to proceedings. It's not hard to think of other cases where individuals may be adversely affected by having their identity disclosed during tribunal proceedings to which they are not a party. Overall, obviously, the issue of privacy in public courts is going to continue to generate cases, and no doubt there will be some difficult balancing acts to be carried out. But it's obviously, the key part in this is that the anonymisation order could be made to protect the convention rights of someone who wasn't a party. I should also say, as I mentioned at the start of the podcast, that Claire Darwin from Matrix Chambers has drawn my attention to the Tavata case, which is not an employment tribunal case, but again concerns issues around individuals being named in a report produced by the Financial Reporting Council, which apparently contained or potentially contained criticisms or comments which could be viewed as critical of individuals working at a third party. She also tells me that the Amayor case, which we have discussed in a previous podcast, has now apparently been appealed to the Court of Appeal. So it looks as if the Court of Appeal too is going to have an issue to rule on these issues. We'll bring you all the news that's fit to print, as always. So that's the A and Secretary of State for Justice and the anonymisation order to protect a child's convention right to a private life. Secondly, Lancaster and Jute Limited and Wildman. This is the case I referred to at the start of the podcast, which decided a point that I thought had been decided many years ago. Fortunately, the point which I thought had been decided, I've been giving the same view as the EAT in this case gives. So on this occasion, no reference to the insurers is needed. Phew. The fact's pretty simple. The claimant worked for Lancaster and Jute Limited. She started working for them on 22nd September 2014. She was dismissed for gross misconduct without notice on 20th September 2016, i.e. just short of getting sufficient qualifying service for an unfair dismissal claim. However, she submitted an unfair dismissal claim and claimed that, correctly construed, the statutory continuity provisions in the Employment Rights Act 1996 allowed her to bring a claim. She did this by relying on a combination of Section 86 of that Act and Section 97(2). Section 86 deals with the rights of the employer and employee to minimum periods of notice. An employer must give an employee who has been continuously employed for 1 month or more not less than 1 week's notice in the first 2 years of their continuous employment. Therefore, here, Section 86(1) gave the individual the right at first blush to a minimum period of 1 week's notice. However, Section 86(6) says, quote, "This section does not affect any right of either party to a contract of employment to treat the contract as terminable without notice by reason of the conduct of the other party." Unquote. I'll come back to that. Section 97(2), which looks at the definition of the effective date of termination, and that's the definition for the point at which continuous service comes to an end, states that where a contract of employment is terminated by the employer, and the notice required to be given by Section 86 would, if duly given, expire on a day later than the effective date of termination, then the later date, i.e. the expiry of the statutory notice period, or what should have been the statutory notice period, that's the effective date of termination. So, in short, the argument runs like this. This individual had a right to 1 week's notice. She was given no notice. On that basis, under Section 92, she says, I should have been given 1 week's notice, and I'm entitled to have that statutory notice of 1 week added on to my actual continuous service, which would therefore take me over the 2-year qualification mark. However, this argument flagged up exactly what was meant under Section 86(6), which said, Section 86 does not affect the right of either party to a contract of employment to treat it as terminable without notice by reason of the conduct of the other party. The EAT. What did the EAT do? Well, the EAT disagreed with the Employment Tribunal. The Employment Tribunal had allowed the claimant's claim to proceed, believing that she was entitled to add on the 1 week statutory minimum notice period. The EAT said that Section 86(6) meant that in circumstances where the individual was lawfully dismissed for gross misconduct, the notional extension by 1 week did not apply. The claimant tried to argue that Section 86(6) merely allowed parties to terminate the contract of employment, and it was not connected to determining the statutory concept of the effective date of termination, but the EAT simply did not accept that was correct. The right to add on 1 week's notice to the period of continuous service did not apply if Section 86(6) applied. As I say, this is an issue that comes up a surprising number of times. Employee relations advisors, employment lawyers, we will all have had from time to time phone calls with a client saying there's a problem with an individual and asking whether the individual can be dismissed immediately before the individual acquires rights to claim unfair dismissal. In circumstances where the individual is close to the 2-year mark, it is always prudent to factor into any calculation to add on the additional 1 week's notice period. Here, the individual is contesting whether she was guilty of gross misconduct, and on that basis the EAT has ordered the matter to go back to the Employment Tribunal. This is presumably to determine whether or not the employer was lawfully able to dismiss her for gross misconduct, in which case the statutory extension did not apply, and the individual will not be able to claim unfair dismissal. So, Lancaster and Jute Limited and Wildman are the circumstances in which an individual dismissed just short of the 2-year qualifying period for an unfair dismissal claim is still able to bring a claim for unfair dismissal, or is not able to bring a claim for unfair dismissal. So, third and final case, Linklaters LLP and Frank Mellish. This is a High Court case dealing with the grant of an urgent interim injunction. It raises similar issues as the NDA case that I spoke about on the podcast before Christmas. And I should make it clear that at this stage the case was one-sided. Frank Mellish did not take part in the hearing before the judge, and so inevitably the version of events put forward by Linklaters and considered by the judge has not been tested in the normal way. Frank Mellish was, for slightly more than a year, the Director of Business Development and Marketing at Linklaters. His contract of employment had an express obligation prohibiting him from disclosing confidential information both during employment and after he ceased to work for Linklaters. That ceased to apply to information which came into the public domain, according to the clause, other than by reason of Mr. Mellish's own personal default. So far, so standard. According to Linklaters, the claimants in this case, whilst Mr. Mellish was the Director of Business Development and Marketing, he gained access to a substantial amount of information about Linklaters and its partners and employees. Mr. Mellish started working for Linklaters in March 2017 and was given notice in June 2018, and he was entitled to 6 months' notice. And then when he left, he was also paid an ex gratia payment. 2 weeks after he had received the final termination payment on 20th January 2019, Mr. Mellish emailed the Linklater's senior partner and firm-wide managing partner to tell them of his dissatisfaction with the termination of his employment. He said that he intended to share my impressions of the current culture at Linklaters, unquote, including in particular, quote, the ongoing struggle Linklaters has with women in the workplace, unquote, stop. Mr. Mellish put Linklaters on notice he was going to give interviews in the first 2 weeks in February. The letter sent to Linklaters by Mr. Mellish referred to 3 examples that he was going to cite, and those are identified in this High Court judgment as the Munich incident, the New York settlement, and the London settlement. Linklaters reacted by applying for an interim injunction to prevent the individual disclosing what Linklaters said was confidential information connected with those 3 incidents. For example, in relation to the Munich incident, the identity of the female complainant was to be restricted. Similarly, in relation to the New York settlement, the identity of the claimant and those about whom the complainant had complained was not to be disclosed. Similarly, detail as to the internal discussions within Linklaters about their public response to any third-party interest or questions in relation to any of the above matters was to be kept private. Note, Linklaters did not seek to restrain the individual from publicising in general terms his impressions of the current culture at the firm. Linklaters' evidence to the judge was that individuals who had complained in connection with the 3 incidents wanted to remain anonymous. As I say, Mr. Mellish didn't take part in the proceedings, so we don't have his version of events. Unsurprisingly, the judge was referred to the ABC and Telegraph Media Group Limited case and summarises this as saying that if there was to be a claim for an injunction to prevent a breach of confidence, the information being restricted has to have the necessary quality of confidence. The information has to be given to the individual required by him in circumstances importing an obligation of confidence, and the defendant needs to be threatening or intending to misuse that confidential information. The High Court judge here also accepted that he had to consider the Convention right to freedom of expression. This involves a balancing exercise, but as set out in the ABC case, the judge emphasised the weight to be given to obligations of confidence which were assumed under a contract freely entered into by a defendant for good consideration. Judge accepted there was clearly a risk that Mr. Mellish would publish this information if not restrained. He also accepted the claimants in this case had to establish it was likely that publication of this information would be prohibited at the final trial, i.e. after full evidence had been heard, cross-examination, etc. Court also accepted that even if all these matters were shown, the court still retained your discretion if, for example, damages were an adequate remedy in the event of publication, or that a cross-undertaking in damages in favour of the defendant would not be an adequate protection for a defendant who was wrongly injuncted. The court accepted that the rights of third parties involved, and I should say these are presumably the complainants in the settlements and incidents, bolster the arguments for the grant of an injunction. The court commented that internal grievance processes, which presumably had taken place in connection with these matters to some extent, are confidential. People take part on the basis that what they say will remain confidential, and there'll be strong policy reasons for upholding those legitimate expectations. On that basis, the judge granted a short injunction until 11th February and set a return date for then, presumably for the defendant to challenge the injunction if he is so minded. I've seen reports since that indicate that Mr. Mellish has said he is not looking to contest the injunction. On that basis, I suspect that will be an end of matters unless there are parts of this case that have not yet made it into the public domain. Who knows? But here again we see a court laying heavy emphasis on the fact that a contract freely entered into by an individual prohibited that individual from doing what he or she was now seeking to do, even though it would appear that the matters the individual wished to discuss publicly related to some form of inappropriate behaviour towards staff by other staff within Linklaters. That's the Munich incident, New York settlement, etc. This was not enough to persuade the judge that Mr. Mellish was entitled to disregard contractual obligations freely entered into at this stage of the interim injunction. So, clearly, these cases on privacy, freedom of expression, etc., confidentiality, are going to keep coming, but for now at least the approach adopted by the court seems to be consistent with the earlier ABC case. So here we have High Court grants an interim injunction to prohibit a former employee from disclosing confidential information about grievances connected with complaints by, I think, women working at the employer. So that's podcast 147 for you. Thank you very much, of course, for listening, and do get in touch if you have any comments, good, bad, or indifferent. good preferably. But if you are a regular or an occasional listener to the podcast, and also if you have any suggestions about things you'd like to see covered, or how we go about this, I'm all ears, really. And it only remains for me to confirm, of course, that no employees were harmed in the making of this podcast in any way. Do you know what? I probably ought to be changing that to say no employees or workers were harmed in the making of this podcast in any way. Thanks very much for listening. Cheers.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.